Olegario V Mari, GR number 147951, December 14, 2009. The facts of the case. As early as 1916, Juan Mari, the father of Pedro Mari, declared his ownership over a parcel of land in Nancasalan, Mangantarem for tax purposes. He took possession of the same by delineating the limits of bamboo fence, planting various fruit-bearing trees and bamboos, and constructing a house thereon. Tax Declaration number 8048 for the year 1951 specified the subject realty as a residential land with an area of 897 square meters and as having the following boundaries: North, Magdalena Fernandez; South, Catalina Cacayurin; East, Camino Vicinal; and West, Norberto Bugarin. In 1974, the subject realty was transferred to respondent Pedro Mari by virtue of a deed of sale. In 1947, Wenceslao Olegario, the husband of Magdalena Fernandez and the father of petitioner Arsenio Olegario, filed a new tax declaration for a certain 50 square meter parcel of land and executed a deed of quitclaim of unregistered property in favor of Arsenio, transferring to the latter the aforementioned 50 square meter property. The subject realty was identified as lot numbers 17526, 17553, and 14356. In 1988, respondent filed with the DNR a protest against the petitioners because of their encroachment into the disputed realty. DNR decided in favor of the respondent and found the latter to be the owner of lot numbers 17526, 17553, and 14356. Petitioners did not appeal, and the said decision then became final and executory. In 1989, Arsenio caused the amendment of his tax declaration for the 50 square meter property to reflect an increased area of 341 square meters. In 1990, after discovering the amended entries in Arsenio's tax declaration, respondent filed a complaint with the RTC to recover of possession and annulment of tax declaration. RTC rendered judgment in favor of the petitioners. CA reversed the trial court's finding. The issue of the case: whether or not the Court of Appeals erred its decision in adjudicating ownership of the said lots in favor of the respondent. Ruling: the petition has no merit. Circumstances clearly show that Juan Mari was in possession of subject realty in the concept of ownership, publicly and peacefully since 1916 or long before petitioners entered the disputed realty, sometimes in 1965. Based on Article 538 of the Civil Code, the respondent is the preferred possessor because, benefiting from his father's tax declaration of the subject realty since 1916, he has been in possession thereof for a longer period. On the other hand, petitioners acquired joint possession only sometimes in 1965. Petitioners' act of possessory character, acts that might have been merely tolerated by the owner, did not constitute possession. No matter how long tolerated possession is continued, it does not start the running of the prescriptive period. Mere material possession of the land is not adverse possession as against the owner, and it is insufficient to vest title, unless such possession is accompanied by the intent to possess as an owner. There should be a hostile use of such nature and exercise under such circumstance as to manifest and give notice that the possession is under a claim of right. Open, exclusive, and undisputed possession of alienable public land for a period prescribed by law creates the legal fiction whereby the land, upon completion of the requisite period, ipso jure, and without the need of judicial or other sanction ceases to be public land and becomes private property. Ownership of immovable property is acquired by extraordinary prescription through possession for 30 years. For purposes of deciding the instant case, therefore, the possession by respondent and his predecessor had already ripened into ownership of the subject royalty by virtue of prescription as early as 1946.